I might as well just get started. I know John said he has to get through about 3 hours of content in 1 hour, so I'm not going to keep him from the presentation. So I'd like to introduce John Pineau. He is a family law, criminal law attorney. I'd like to give a thanks to our family law section chairs, Brittany Frisbee and Sarah Zolo, for bringing John to the Boulder County Bar to present today. He has requested that if you have any questions during the presentation, please send them into the chat function. Do not unmute yourselves. And then at the end of the hour, I'll be reading those to John so that he can answer those. He's also going to make himself available. He said I can even send out his cell phone number. So if you have any questions, he's going to make himself more than available for those. And I will also be dropping a PDF to the handout that he's going to be referencing during his presentation. I'll drop that in the chat in just a moment. But for now, John. Thank you, sir.
Thank you, Kyle. How you doing? Can't see anybody. It's entirely weird to do a presentation this way, but I'm trying to adapt to the 21st century. So about 15 years ago, there was a big meeting with a bunch of muckety mucks down in Haddon Foreman in their large mansion down there to discuss why our clients were more likely to commit suicide than be released from the Department of Corrections. And we came up with a number of options. The first option was that we file a federal class action against DOC pro bono and try to improve the chances of release by improving the likelihood that treatment was being funded. And the other one that was kind of second on the list was that we talked to family law attorneys and explained to them that if you plead your guy, if you are handling a family law case with a custody dispute and you plead your fella into a you decide to do the criminal case as well, and in that criminal case you plead your fella into a probation sentence, that it's likely he won't complete that, and because of the way the law was changed in 1998, he's more likely then to go to DOC on a life sentence and die there. And so we thought that that was important as well. We ended up doing the federal class action for about 10 years. It was a financial disaster for me, but a successful outing in terms of improving Department of Corrections and improving the release rates for our clients. But now time has passed by, and I'm here to talk to the family bar in particular about sex assault cases, particularly when they're combined with a DNN case, custody fight, and a sex assault on a child case. I have 4 overviews. Number 1, the criminal procedure is very clear to me, and I'll be somewhat confident in explaining the criminal procedure part of this triple threat, right? The DNN and the divorce side of it, I'm largely just parroting like an idiot, parroting things that I've heard from other practitioners who know what they do. So my kind of ability to express those things, my fluency on those matters is probably not going to be as clear. Number 2, there's really no map. I'm not going to give you jelly beans to follow to the promised land. Instead, what we're going to be talking about are pitfalls and opportunities that occur, but there's really no singular pathway that everyone, if they follow it, will find a safe passage for their clients. So forget about that. We're going to talk about dangerous areas and opportunities. 3, my bias. I have 0 problem representing people that are facing these charges. First, particularly when there's a custody fight, the data is clear. When there's a custody fight context and an allegation of sex assault on a child, the number of false reports increase 6-fold. We say it again. When there is a custody fight context and an allegation of sex assault on a child, which is a life sentence charge, the likelihood of a false report being the basis for the allegation increases 6 times. So I don't have a problem representing people facing this. I don't have a problem facing somebody who's even guilty of these charges because they're looking at a life sentence and they are then going to die in prison. As a child molester, that's not a pretty way to end for anybody, and it seems a little excessive to me. And then last, as a nation, we put more of our citizens behind bars than any other country on earth. That is a disgrace. So I have no problem standing here representing the defense. If anything, the people on the other side should be looking in the mirror. So number 4, forgive the speed at which I'm talking. It's going to be like drinking from a fire hydrant during this thing because I have a lot of content. I think about 3 hours or more, but I'm going to try to make it in 1 hour. So if you have questions, just call me for clarification. I am not giving you my cell number, but I will give you my office number. Kyle mentions cell number. No, you will get my office number. I'll give it to you now, 303-440-4444. You can call me anytime for any reason, 303-440-4444. You'll also notice that I'm not giving you a lot of sites. Why? Because I don't want these Trojan horses that are in the data that is relied on by prosecution experts to be exposed more than necessary. I don't want to provide all that intelligence to the other side in the course of doing this lecture. I'd like to be able to get my clients through these problems in one piece. So let's go. Let's start with a description of the 3 areas. First, sex assault on a child. That's generally an allegation of a touching or penetration of a child by an adult. There is a mandatory life sentence to prison attached to those charges. In particular, if it's a sex assault on a child allegation where there's force or a threat involved, mandatory life. If it's sex assault on a child and it's a pattern, meaning just 2 touches, and a pattern could be simply, and I've seen this case, been involved in this case, the allegation is that there was a touching, the person backed away, then approached again, did a second touching. That was determined by a court to be a pattern. So when you have that 2 touchings, that becomes a pattern. That is a mandatory life sentence, meaning that if the judge is the brother of the accused, the judge, if that accused is convicted, still must send him to prison for life. Number 3, position of trust. Be aware that the position of trust definition means that if you have responsibility for a child, no matter how brief, it's essentially a quote from the statute, that you're in a position of trust. And if you perpetrate a sex assault on a child under those conditions, you're going to prison for life. And they don't pull punches on these cases. The prosecutors in these cases are very motivated and skilled in achieving convictions in these types of cases. All the other sex assault allegations, including incest and other things like that, involve typically sentences where there's a possibility, a range of a sentence that can go anywhere from life probation up to lifetime in prison. So let me tell you how that works. So if you get a conviction or plead into these other offenses where it's probation to life imprisonment, the judge can do whatever they want with that, from a very long probation term all the way to a life sentence to prison. And so that's, for example, incest. That's the range of sentencing there. But if the judge sentenced the person to, on day 1 at the sentencing, to prison, they must send them there for life for those types of offenses. Probation can be revoked on that kind of a sentence, so they end up with probation. You'll see these really sad numbers in just a moment, but they end up on probation, then that's revoked. Then the judge must send them to prison for life. Again, a life sentence. And be aware, it's life. It says in the statute for the rest of their natural life is how they have to be sentenced. The sentence on these cases is unlike all other criminal sentences in the sense that what happens is the judge says, if it's a sentence to prison for life, that you are now sentenced to prison for life, and I'm going to give you a possibility of parole after, say, 10 years or 16 years or 32 years, whatever it might be, meaning they can stay there for life, die. There's nothing they can do to complain about that. But if they successfully complete treatment and everything else, then they are eligible to be considered for parole at 10 years or 16 years or some other year. So it's essentially life with the possibility of parole, but the parole numbers are bleak. So, also, by the way, it's an important factor to tell your client about. Lifetime registration as a sex offender. Particularly for sex offenses on a child, you do not become ever eligible to deregister. So in other offenses, after 5, 10, 20 years, you can apply for deregistration. But if it's sex assault on a child, that's the underlying conviction, you are never eligible to deregister as a sex offender. So you'll never be able to, say, work for McDonald's or anybody else from that point up, right? That's an important factor for your client to know when assessing whether to go to trial or whether to take a deal that's going to basically end their life and leave them living under a bridge. So let's talk about some of the, oh, by the way, if you're paroled from prison somehow, it's lifetime parole. So in the materials, you'll see that in the last 16 years, people that have been placed on probation under all sex assault sentences, including determinate sentences, 28% of them has successfully completed, meaning 72% of them are still in prison or still under serving. So a very low rate of success. And that includes determinate sentences. So if you put only life sentences in there, likely that you would find a much lower number. That number is 20%, 28% for Boulder County, 20% for Denver. And then for every person who has successfully completed SOISP, that's sex offense intense supervised probation, it's only 9% of people that are placed on it that have completed that since its outset in 1998. 3, for every one that successfully complete, 3 are revoked and terminated from SOISP and likely sent to DOC. Those people that are placed on deferreds in every county in the state, well over half of those people that are placed on deferreds, it's fairly rare, but when they are, well over half of them have been revoked in every county in Colorado. 92 since the Lifetime Supervision Act, 92% of the 3,128 people that are in DOC on these sentences are either still there on parole or have died under DOC supervision. If you go to one of these sentences to DOC, it is 4 times more likely that you will die under DOC supervision than that you will successfully complete a sex offense sentence at DOC. You are 4 times more likely to die than to be released successfully on the sentence. Very important fact to represent to your client before they make the fateful decision to take their chances with the jury or take their chances with a plea. So let's move along to describe some basics about a DNN. DNN, of course, is a civil case where they're determining whether the kids are dependent or neglected. According to the official DNN handbook, quote, a dependency and neglect case is filed in court because the County Department of Human Services believes that you or your family could use some help in learning how to protect your children. Sounds like complete sunshine and rainbows. And compared to the criminal side, it kind of is, because the ultimate goal of the DNN is to reunite the family. The adjudicatory hearing is key, and that's where they decide whether the kids are dependent or neglected. You can ask for a jury of 6 for that trial. And if you don't do well, if the kids are determined to be dependent and neglected, you're placed on a plan. If that does not go well, then you proceed to a termination of parental rights hearing. That's where your parental rights can end and no more contact with your kids. And of course, C, it would be part 3 would be a custody fight. I'm not going to explain that to family law practitioners, but essentially that is a civil dispute over parenting time. The underview to all these is that the criminal case is catastrophic and that the other 2 are survivable. There are dramatic results in the other 2, the DNN and the custody fight. But the criminal case can literally kill your client. It is lethal compared to the other 2. And so when you'll see, when you talk about the pitfalls, that every person I spoke to agrees that the criminal case needs to take priority. So let's move to the literature. The scientific literature here is critical in many ways. I'll explain them as I go, but the number one reason is that it's critical is that it provides a theme for your case, because if the literature provides an explanation for why a false report was created, and you can find that foundation in your facts, now you have the science and the facts supporting your theory that this is a false allegation. So in these cases, be aware that it's very common, almost in every case, that the prosecution lists an expert. And this prosecution expert, their primary job is to take things that would appear to be reasonable doubt, like a late report, inconsistent report, a recant, to take those and not only say that those are okay, but to say that those actually add up to more proof that the crime occurred. So they take things that you and I might perceive to be a reasonable doubt, like the kid says it didn't happen now, and say, well, no, actually, in my experience as an expert, we see that happen all the time. And so that actually is more proof that this assault really occurred. The data doesn't support that. The literature doesn't support that. But that's what they say. So that, the fact that the kid is recanting or eating pickles or whatever it might be, they'll say that that equates to them being a victim. One thing that's really important when dealing with these experts is they never talk about statistics for their conclusions. Why? Because all the statistics don't support or contrary to the conclusions. And it's fatal if it's done right, treated right, or explained properly to a jury or a judge, because if it turns out that only 1 in 1,000 kids recants, and 999 maintain the same story, then the fact that in your case the kid is recanted actually indicates that they are unusual, highly unique, and don't fit statistically, and in fact inconsistent with what's normally presented. So their absence of statistics is something that needs to be looked into. On the defense side, you need to get your own expert, and you need to get them early. They will guide you. They will guide you to the scientific literature that's important. They will point out inconsistent facts, that inconsistent facts do occur, but most kids report timely and consistently, that's what the data shows, that it's that they can identify mistakes that occurred in the investigation or in the forensic interview. They can identify things that are missing. They can help you admit your literature if the prosecution expert bucks you and doesn't allow your literature to come in. So let's take a look at the literature in particular. You need to get the biography of the prosecution expert. I just had somebody walk in, and I need to apologize to him too for why I'm going so fast. It's because I have 3 hours of material, and while I'm doing that, I might as well thank the people I've spoken to. So just a sidestep here. I spoke to Lori Rose Kepros, the queen of sex assault cases across the state, works for the public defender's office. Jean Bankart, county attorney who handles DNNs for the county of Boulder. Joe Picard, who did that for the Jefferson County, and is also a criminal defense attorney. Katrina Weigel, who is nothing less than a heavyweight in the world of prosecuting sex assault cases. Chris Estel, who formerly prosecuted these cases and has been a GAL as well. Vince Todd, who I can see appearing here. Robert Wiest, who is a GAL in a case we just handled, or a DNN lawyer in a case we just recently handled. Chris Jeffers, Nicole Collins, the head of the public defender's office in Boulder. Bob Miller, my legal stepdaddy, who's here in the office. Ingrid DeFranco, who is a former clerk for the Chief Justice of the Supreme Court and my best friend in the law. Chris Seltzer, and Chris Decker, who is a sage for all things criminal and a sage for all things generally. So going into this, the literature. You want to get the bibliography for their expert. You want to go to their office and interview them. You want to walk through their office and point out on the shelves the books that they think are important and get those books as well. Then you want to read everything, and do not sidestep this. In the last case we did, we spent 10 days with me with a little board that held books in front of my face with my eyes pinned open like in Clockwork Orange, and read for 8 hours a day for 10 days straight till we went through all 100 articles that were listed and all the books that were listed. And what we found was a treasure trove, which is what we find in every case when we do the work. So I'm now going to go through the literature solely gleaned from or extracted from prosecution experts, not our own experts, which would give us much more, but prosecution experts. These are the things that we find in the prosecution experts' bibliography if we do the work. So for example, the best one is kind of comic relief. This expert only listed 2 books. I only had to read to and testified, of course, that the things that were present in our case were indicia that the sex assault had occurred and indicia that our guy was guilty, essentially. We only had to read to page 13 on one of the 2 books she listed, where we found, quote, quote, "It must be stressed that this book focuses on convicted child molesters. It would be a serious mistake to try to apply these ideas to someone you simply suspect of being a child molester, but who has not been charged or convicted." That was the beginning of a fantastic cross-examination. Let's go through the rest of the data. The U.S. Department of Justice on a yearly basis lists the number of people that are accused of sex offenses but excluded by DNA. 25%. People that are identified as the accused, as the perpetrator, then the DNA comes in where it's dispositive. 25% of them are excluded in state-run labs, 26% in privately run labs. Think about that. So that's a case where DNA actually can exclude somebody. Your average case, DNA isn't even a factor because the allegations are so old or whatever it might be. In those cases, you would expect this exclusion rate to be even higher because the likelihood that they identified the wrong person increases. So it may actually be higher than 25% where we don't have DNA. It's important to note that any solid detective in this area will admit on the stand under oath that false reports exist. So you want to get that in your transcripts, particularly at the preliminary hearing. Third, Much of the data is driven by the seminal book, Jeopardy in the Courtroom, which was written by Professor C.C. and Bruck out of Cornell. And their data, the collection of data to this day is still important because it's seminal. So it's not dated anymore. It's like saying that the origin of the species is dated. It's still good. And then you can from that find all the other data. That book was triggered in part because of the Little Rascals problem, where 90 children were alleged to have been sexually assaulted at a daycare center. 7 adults were arrested. The lead defendant, Bob Kelly, was convicted on 99 of 100 counts and sentenced to 12 consecutive life sentences, all of which were reversed when they looked at the data and looked at what actually happened. And that's what we're going to follow and find out about below. In C.C. and Bruck and other researchers as well, they state that when there is a custody dispute context to a sex assault on a child allegation, that custody disputes increase false reports by 6 times, 6-fold. That in custody disputes, in that kind of a context, that the rate of false reporting is 33 to 35%, and that they believe that these numbers underestimate false allegations. That is a stunning fact when you consider that the person who is on the wrong end of those allegations is on their way to prison to die. C.C. and Bruck quote, "New studies show kids construct highly elaborate, coherent, and believable narratives that happen to be highly inaccurate." Quote, "Children's reports can be unreliable because they confuse, omit, or blend details when recounting an actual event, but they can also be unreliable because they fabricate an entire episode or sequence of events within a larger episode." The frequency of sex assault is too high, but probably not as high as we would guess from reading mainstream media. So in terms of kids that are abused, sexually abused per year, it's about 1 in 500 for all kids from under 18. For intrafamily abuse, which is most cases, the rate is 8.9 out of 10,000. That's less than 1 in 1,000. About 75 to 80% of the victims are female, and 42% of children report their assault within 48 hours, not 3 years, within 48 hours. Among kids that are referred for evaluation for abuse, at least 50% are not abused. And those that are referred are often at risk for false positives for reasons we'll discuss below. The motive for false allegations, quote, motivations to lie: A, avoiding punishment; B, sustaining a gain; C, keeping a promise; D, achieving personal gain; and E, avoiding embarrassment. Quote, "The safest conclusion that can be reached at this point in time is that subjects of all ages will lie when the motives are right. Children may be no different than adults in this regard." Parents cause false reports. Quote, "False reports may come from social demands, efforts to please loved ones." Quote, "Some allegations grow out of interviews conducted by parents who are convinced that abuse took place and who relentlessly pursue a single hunch in conversations with their children." No surprise that we see a higher rate of false reports when there is a custody fight. A therapist who is biased, confirmatory bias, leads to false reports. Quote, "Some evaluators come to the evaluation with a bias that kids referred have been abused and or kids do not make serious misrepresentations." Quote, "Strong initial beliefs tend to undo the accuracy of the assessment." When an interviewer has been given false allegations before they go in for the interview, which is true in almost every case, they have some understanding what the allegations are before they go in for the forensic interview, or the therapist certainly has been given something by the parent that brings them there. Misinformed interviewer causes 34 to 18% of children to give false allegations. It gets worse, and just read this one directly from the source. Quote, "By the end of the first interview, 75% of the children's remarks were consistent with the interviewer's point of view, and 90% answered the interpretive questions in agreement with her point of view, as opposed to what actually happened." 75 to 90%. when the interviewer has a prior false story on which to go on when conducting the interview. Another really terrifying fact related to this is that when a kid is given a false, these studies have done it where the kid is given a false narrative, and he gives a false narrative to the interviewer, and then the interviewer incorporates the false narrative, the kid becomes more confident and sure of the false narrative. In other words, so you told me that you were touched 3 times. Okay, so when he touched you those 3 times, did that happen in the house or outside? And when the kid hears that, the interviewer incorporating those facts, they become more confident and sure of the false allegation. When you think about the interviewer, just insert mother or father, right? Because the interviewer does not have to be a forensic interviewer for these unhappy results. It can be simply anybody who's doing the interview. Repeat interviews undermine accuracy. The average child witness is questioned 12 times, and that is an underestimate due to the number of times parents, friends, and mental health professionals question a child. Quote, it is also true, as we will show, that some children are repeatedly interviewed until they provide the desired testimony, unquote. Delayed reports obviously increase the number of false reports. A long delay in report equals lower accuracy. Quote, after a year, more than 50% of 5-year-olds reported the suggested false facts, and 38% added new false facts of their own. So more than 50% are adopting the false fact, reporting it a year later, then adding on to it. Another 38% are adding on to the false facts, the narrative that they were given by whoever coached them into that in the first place. Slander increases false reports. In other words, if the person that's a target is constantly being slandered by the associates of the child, it increases false reports. Children made false reports about incriminated or slandered target at a higher rate. Emotional tone. Children may give false statements to misleading questions. Children may give statements to misleading questions for which they have no memory if the interviewer creates an atmosphere of accusation. Just imagine how those interviews go on back at home when their first suspicions arise about these types of allegations. Peer group leads to false reports. Quote, children will change their answers to be consistent with those of their peer group, even when it's clear that the answer is inaccurate. These are quotes from the sources from the prosecution's experts, right? That's what I'm providing you. That's what the data actually says. The power of the interviewer. Quote, the child's recognition of this power differential may be one of the most important causes of their increased suggestibility. Children are more likely to believe adults than other children, and they are more willing to go along with the wishes of adults to incorporate the adults' beliefs into the reports. This fact has been recognized by researchers since the turn of the century, unquote. Ending an interview. Quote, previous research indicates that when children want an interview to end, they often increase the quantity of false statements. There's no check for truth. I don't know how many forensic interviews I've reviewed. I've never seen this. Interviewers do not ask, did that really happen? Did your mommy or daddy tell you that this happened? Never happens. Most fundamental question in trying to get to the truth would be, did someone actually tell you to say this? We're just going to adopt everything that's said and record it and make a transcript out of it and use it as a basis for a prosecution on a license case, but never ask whether anybody coached this information into the head of a small child. False reporters are sure of their story. This becomes really frightening to me. Quote, individuals of all ages become very confident about their memories, regardless of whether they are accurate or inaccurate. So they're sure of the false allegation. Quote, when children who provided false reports were confronted with the error, most of the children who had assented to false beliefs in previous interviews continued to hold on to their false statements. So you confront them, they don't just fall apart on the stand. In the most difficult cross-examination in the law of a 7-year-old child, I dare anybody to say there's a harder cross. They, when confronted, stick to their story. But the jury and the judge need to know about this. Oh, another terrifying fact, quote, there are very few cases in which adults, even highly experienced experts, can detect whether a child's testimony has been tampered with by another adult. more disturbing facts based on the literature and the science. Quote, after 2 studies done in 2008, a child who tells a long, detailed story is more likely to include a high ratio of inaccurate details in that story. Most of us, when we hear a story like that, that's long, detailed, we think, wow, is this kid telling the truth or what? It's a long, detailed story. The opposite is actually the case. It's important to note that there is no list of, hold on here. I have too many books. Actually, there's never really too many books, is there? Only too few. There's no list of symptoms that are correlated to sex assault victims. I want to read this one directly from the text. How am I doing on time?
Okay.
Quote, there is not a scientifically based behavioral instrument to rely upon for drawing an accurate conclusion about the occurrence of abuse or the identity of abusers, nor is there an established actuarial model, as in other areas of forensic inquiry, that provides reliable guidance. No empirically based list of behaviors, symptoms, supports relevant determinations. There's simply, the fact that the child's acting this way or that does not indicate whether that child is a victim. In fact, I'm going to go to 116. Quote, many of the problems discussed in this chapter, including sleep difficulties, toileting issues, and physical complaints, can be prompted by sexual abuse, but are more often associated with normal developmental issues, medical problems, and disruptions in family routines or other stressors. These behavioral problems are not useful indicators of sexual abuse by themselves because they occur so frequently in non-abused children, but also because the circumstances surrounding false allegations can prompt a wide variety of stress-related reactions that mimic reactions to abuse. In other words, if this kid comes from a household where a parent feels justified in coaching false allegations, that stress actually mimics the behavioral problems that are associated with an actual sex assault. I mean, I can't even imagine anything more diabolical than that, given the world of hell that this innocent parent is being thrust into as a result of a false allegation. It's important to note that school age and adolescents are more likely to disclose to young kids. Older kids are more likely to disclose these things to peers, and young kids to a friend. And I've lost track here. Finally, going to the DSM-5, probably everyone's familiar with this piece of the DSM-5. Well, quote, malingering should be strongly suspected if any combination of the following is noted. Number 1, medical legal context of presentation, to include when litigation or criminal charges are pending. So an expert that's doing their job should be considering malingering, which is defined as false or exaggerated symptoms or claims. That's the number 1 thing they need to suspect when there's litigation about a particular criminal litigation. Finally, some of these cases, if alcohol didn't exist, I'd have nothing to do as a criminal defense lawyer, about 85% of the time, including sex assault cases. But if alcohol is a factor, you need to get a toxicologist because of the following. Quote, alcohol can prevent storage of peripheral details and at higher levels of impairment, central details too, and in blacked out or passed out states, all is lost. But as with stress, there's no scientific basis for assuming the inaccuracy or accuracy of any details that do survive alcohol's effect. Prosecution expert. Now, my favorite parts, confabulation. I can deal with this briefly, but confabulation is not just my favorite word, but also the data is very interesting. Bessel van der Kolk is kind of a saint in this area and often relied on at the top of the list for many prosecution and defense experts. He writes, like all stories that people construct, our autobiographies contain elements of truth, of things that we wish did happen, but that did not, and elements that are meant to please the audience. Stories that people tell about their traumas are as vulnerable to distortion as people's stories about anything else. And then really what I think is most fair and balanced explanation possible is generated by a group of Harvard researchers fairly recently, who state, quote, please listen to this carefully. Unfortunately, when victims do not know the answer to a question, they often feel ashamed of not being able to make a useful contribution to the investigation. They may even feel that they failed the investigator, or worse, that they failed themselves. As a result, many victims fill in gaps in their memories based on what they think must have happened or even imagined happened, as they strain to recall what the investigator is asking for. In this case, it is critical to understand that victims are not lying to or deliberately making things up. They are simply doing what people do all the time when they are sincerely trying to remember things that are not entirely clear or filled out in their memory. They are filling in gaps, often without even realizing that that's what they're doing, because it's such a common thing that people do all the time. That sounds like real human behavior to me, but what's even better about that is it allows the defense not to make a demon out of a small child or even their parent, because what they're trying to do is honestly fill in the gaps in a way that may turn out to be overprotective and ultimately generate a false report. But you don't have to demonize a 7-year-old or a parent in order to use a theory that's consistent with that research, which is that the confabulation is simply somebody trying to fill in missing gaps. I think that's a really effective way to talk to DAs, judges, and juries about what might have happened. So that research provides the theme if your facts are there. All those branches of research, you may be able to hang the facts on those, and now they make sense because they're consistent with the data, the science, the research, and your expert's testimony, and conceivably the prosecution's expert testimony. So that becomes something that's compelling in the course of a jury trial on a life sentence case. Let's now talk about pitfalls and opportunities. In criminal cases, number one, the criminal case needs to come first. I know that it's extremely important to have custody of the children, but the criminal case has to come first, because if you're representing the father or the mother with these allegations, you don't want them to die in prison. So that has to come first. Number two, you need to advise the client about all the criminal consequences, in particular, the possibility that they could go to prison and die, or if they take a deal or whatever it might be, or if they take a deal, they could go to prison and die, or that there's lifetime registration and they may never get off of that and they may never hold a regular job again, right? You need to get the entire family involved, right? Because it's devastating. This is likely the most difficult thing that any human will go through. And so they can't keep it a secret from their immediate family or their extended family. Everybody needs to be involved, if for no other reason, because how are they going to pay all the fees for this, right? The criminal fees, the D&N fees, the divorce attorney fees. You need everybody involved, including grandma with her second mortgage, in order to be able to survive this financially. Number four, you need to warn them about pretext calls. Not as common in child sex assault cases, but they could have the mother, very common for police to use pretext calls, to have the mother call up your client and just try to engage them in a conversation where even if he says, I'm sorry, it'll be perceived as negative. So you need to tell them, do not discuss the case with anybody, including your wife or whoever it might be who's calling to talk about the case. Because these pretext calls, of course, are recorded by the police, and the police script the call. Discipline. You need to impose strict discipline because there's no room for error. You need to warn the client not to talk to anybody. You need to have them practice that. You need to have them practice what they're going to say if the police actually show up and do an interview or another search. You need to threaten their life in case they don't follow those orders, so they take it seriously. I usually threaten them with either a baseball bat or a shovel. They need to be afraid of you, more afraid of you than the system. You need to warn. One thing I'll tell them is, think of a really bad science fiction movie where some terrible teenagers, some 20-somethings and teenagers are making their way through a dangerous jungle. And who's going to die first? It's always the guy who's talking that everybody hates. They almost want the guy to be eaten by the giant snake. So you need to tell them, you do that, you're going to be dead. My job is to keep your head down so that you make it through this jungle and the giant snake does not eat you. They need to be serious about that. If necessary, you need to change their diet because this is going to be physically the most difficult thing they ever went through. So if you've got somebody who's not healthy, you need to get on that. You need to tell them about eating the right things and exercising. That's next, physically active. We know that being physically active outside is more effective to this date still than the most powerful mood enhancers that we have. Now, those mood enhancing drugs are important too. You should use those if those are prescribed. But you need to get them outside. You need them to be physically strong because they have to survive this mess. And it's difficult to get through it. And we don't need anybody fading on us halfway through the preparation. You need to give them a meeting list, a reading list. I'm not going to disclose that here. Call me if you want to know what your client should be reading. You need to dress them for court. Do not let them make their own decisions about what to wear to court in a life sentence case. Dictate to them exactly what the uniform is going to be, and they need to comply. If they don't, you're off the case. You need to tell them about fees through a verdict, because most of these cases, if you're doing them right, need to go to trial. You're just setting your client up for prison in many cases if you're dealing it. So many cases have to go to trial, and a higher percentage of them do go. So you need to talk to them about what the fees will be all the way through the verdict. So they're not in a situation where they say, well, I'd like to go to trial. What are the fees going to be? And you say, well, it's going to be another gazillion dollars. And they go, oh my God, I guess I'm going to have to take the deal because I can't afford justice. That would just, that doesn't sit right with me. So you need to have them know from the beginning that what the fees are all the way through. You need to talk about suicide. If you've ever had a client kill themselves, I have. You don't want to ever do that again. It's dark and as bad as anything can be. So you need to openly talk to them about suicide, because many times that's what's going through their heads. What I usually do is tell them in the most awkward and direct way that suicide would be really stupid now because it's premature. We don't even have a trial date. What are you going to kill yourself for? We don't even know what the outcome is going to be. Number two, you're going to go see a therapist ASAP, and I'm calling them now and scheduling an appointment because I'm not qualified to keep you from killing yourself. But in the meantime, be aware that it makes no sense to do it today because we don't even have a trial set. Suicide, point number two. You could kill yourself pretty fast by putting a gun in your mouth, pulling the trigger, but a quicker way would be that during cross-examination, you act like a jerk to a 7-year-old who's testifying as a victim in a sex assault case, right? In front of a jury, act like a jerk to a 7-year-old during cross. You will not only be committing suicide, it's actually murder-suicide, because you'll be shooting yourself and your client is sitting right next to you. There's no cross-examination that, if well-crafted, can't be delivered in a whisper and be effective. Number 9, you need to go to the scene immediately. Go to the scene with an experienced investigator. Go to the scene with an investigator that has a UV light, because there may be bodily fluids that you have to take a look at. Be aware, do not change or touch anything. Just take photographs. If you change or touch anything, you could find yourself facing a felony. But you need to get there. Not only because all this physical evidence is available and the photographs are available and the video that you took of the house, which the juries love, they actually reach out and embrace any physical exhibit, because it's not just some lawyer's hot air, but it's a physical exhibit that they can look at and start to understand things. But because when you're in the space, you understand how everything works, and you can start to hang things on the structure, and ideas pop into your head like crazy about what you need to do next in order to defend this case. So you need to go to the scene at your first opportunity. You need to secure all the text, email, social media, and everything. I imagine everyone's familiar with this. I think in the last 5 years, there hasn't been a single case where the text messaging history between the accused and some other person hasn't been one of the most critical facts in the trial. Everything else is just people testifying who may or may not be telling the truth, but a text message, a whole compendium of text from before the allegations even occurred, the jury understands is more likely to be true than anything they hear on the stand. You might want to consider a polygraph and a psychosexual evaluation, a PSE, and a PPG. The polygraph may be helpful because it may be helpful in talking to the DA if it's a marginal case. If it's not a marginal case, the DA probably won't give it much weight. The PSE, again, might be helpful if it's a marginal case and your client's at low risk, although anyone who can afford your fees has probably never had an offense before. The PPG It's unusual. That's where they measure your sexual interest by putting a sensor around your penis. And at least males in our audience, they put a sensor around your penis, and then if they play provocative music and pictures and soundtracks and things, and they measure the response of your penis to determine what your sexual interests are. We recently were able to get a case dismissed in part because of the PPG, because our client was so old, his penis did not work. And so we demonstrated that by putting him on a PPG, which ran every kind of sexual scenario you could imagine, including deviant sexual scenarios, and his penis flatlined, right? So pretty hard for him to do what was alleged in the criminal complaint with a penis that did not work. So that combined with his urologist notes was able to get a life sentence case dismissed. Discovery is self-evident, but I imagine you need discovery of all kinds. Now, of course, you need body cams. You need to get transcripts of all these things in order to be able to really use them. That means all the criminal discovery, the DNN discovery, and whatever's happening in the custody case. And I'll talk in more detail about that below. Number 13, try to get one lawyer or all the lawyers handling these three types of cases under one roof, because if nothing else, it reduces the cost to the client. And as the commander in chief of your side, you need to manage the beans and socks. You need to be able to put a fighting force on the field with the money that you've got. So if you can save money, you're improving your fighting ability in the case. You need to talk to all players before you make critical decisions. So again, there's no, I can't tell you go from A, B, C, and D, and then everything's going to be beautiful, full of cherries. It's not like that. So every decision you've got to run past everybody you know, and still they'll be hard, but you got to make the best decision you can at each point. Live in the present on the case and plan for the future. If there's alcohol involved, you need a toxicologist. I think probably people understand this, but the difference between blackout and pass out needs to be explained to a jury, meaning that somebody can be the life of the party, be totally conscious and volitional in what they're doing, but not remember any of it because the level of alcohol in their bloodstream makes it biochemically impossible to create memories of those moments. So the next morning they remember nothing. And many times young people who've never had that blackout experience before assume that they were passed out when actually they were just blacked out. And so they assume that anything that happened during that time frame didn't involve them in any conscious state, which can be a negative fact. You want to endorse and retain a sane nurse. We use Valerie Sievers, who is the #1 sane nurse trainer in the state of Colorado, essentially the architect of the sane nurse system. So you need a sane nurse because even normal results in the sane exam, meaning bruises, redness, small inconsistencies found in the forensic evaluation of the genitalia, are often entirely normal. You can usually get that from the expert from the state, but they kind of don't want to say that. And so it doesn't come out as cleanly as your own expert who will verify that no, these results we see here are entirely entirely consistent with normal wear and tear or normal use, as opposed to a sex assault. You need to interview everybody, but not alone, right? Interview everyone that's involved, but have an investigator or an assistant with you, like you're sending it here, an assistant with you when you do that interview. I'm just going to and then make decisions about whether you need to record those interviews or do affidavits or anything like that. You need to prepare your client to testify from the beginning. Client needs to live with you and understand every aspect of the case. You need to prepare them to testify. They make their decision about whether they're going to testify or not, but assume that they will. You need to read The Art of War and watch Seven Samurai. That's the end of my things to do on the criminal side. On the DNN side, now I'm speaking about an area that I don't actually do, but talk to lots of people who understand it. There is a split on this very first one. The people that I think I'm depending on or as more reliable say the following: set it for trial every time on the DNN. Set it for trial every time. Pick a jury of 6. Depending on the jurisdiction, you can get your DNN trial, which would mean that this mother or father who's making false allegations could be on the stand in 2 months, 3 months, 6 months, or 9 months, right? At the adjudicatory hearing. 2, ask for depositions. It's a civil proceeding. Some judges will allow you to do depositions, let's say of the mother or father that you suspect is making up these allegations. 3, get the DNN file from counsel for the DNN, or you're the DNN counsel, get the file, because the DA will use a jowl letter to get the trails reports, but there's much more than that. And in a recent case, we got all the jowl stuff, the trails reports, then we asked for the stuff from our DNN lawyer and got the most exculpatory document in the entire case, where the kid was on their first interview repeatedly denied that anything happened, that anybody had abused him in any way. That document somehow didn't make it out. And I don't think there was bad faith. The more I've talked to people about it, I think what happened is that the social worker or something somehow missed it. And it turned out to be the most important document in the entire case, and probably led to the dismissal of a life sentence case for sex assault on a child. So you need to go through all sources. I've also provided a letter that came from Jill Picard in the materials. He uses that, says it gets more material faster than going through any other means. And he used to do all the DNNs for Jefferson County. By the way, the DAs use these trails reports for impeachment and to get important family information, background information. DAs, by the way, can just call the caseworker and the DNN and ask them what's going on, right? They're supposed to be confidential, but they can just call at any time and ask for an update on the status of the case. The DA, by the way, at least in Boulder County, will be advised if your client takes a stand in the DNN. In other words, the county attorney sees that your client's taking the stand, the DA will get a call, hey, so-and-so, the defendant on your criminal sex case, is taking the stand in this DNN, so that the DA can come in and watch that. Ask the DA, here's something, you can ask the DA at the outset, and I've heard that this is likely to be effective. Ask the DA at the outset, look, you're not going to use anything that's in the DNN in my case, right? Will you at least pledge that to me? And many evidently will, for reasons I'll talk about below. DAs often make their decision, of course, on the criminal case, regardless of whether the DNN is unfounded or founded. By the way, statements made to treating professionals in the DNN case, quote, are not admissible in a criminal proceeding for any purpose at all. That's 176 P3D 878 in the interest of IL. 176 P3D 878. Advise the client to be prompt, be best, be prepared, be involved, get help, cooperate with the caseworker. Do not mention the court to the kids. Do not complain to the caseworker, complain to the lawyer, and take the whole DNN process seriously. Have the best possible relationship with the kids' GAL. I'm going even faster now because we're running out of time. Talk to the county attorney. In the DNN case, they are collaborative. So you can call the county attorney and say, you know, I don't know what I'm doing. I need some help here. And they will actually help you. It's different when I call it a DA. I can't really, you know, and it should be. But when you call the county attorney and the DNN, they will actually help you out. The county attorneys I talked to and the county attorney in Boulder, some of the most helpful interviews I did for this entire process. A lot of the materials that we have came from them. By the way, overall, there isn't, I always suspected this, but according to many DAs and former DAs, there is very little leakage between the DNN case, the substance and facts in the DNN case, and the criminal case. One ex-DA told me that was because DAs spend all their time complaining about having too many cases and not being paid enough. So they don't have time to mess around with going and looking at the DNN case to find out what happened there. By the way, you're not going to be able to get that kid on the stand in the DNN. You can subpoena, do whatever. It's not going to happen. I have a bunch of reasons, but the best one is the last one, where one attorney with experience said, if you put the kid on the stand, quote, the judge will have your nuts, unquote. I'm going to update that. Nuts or ovaries is probably what he meant. 16, a county attorney can put your guy on the stand 100% of the time. The DNN should trump the divorce in terms of parenting issues, because they won't go forward on the parenting issues in the divorce until the DNN is resolved on those issues. Plea bargaining. If you do that, there's a huge split in the people that I talked to between 19.3.102.1c, 19.3.102.1c, the child's environment is injurious to their welfare, or a plea under 19.3.102.1e, 19.3.102.1e, the child is without proper care through no fault of such parent. before you accept either of those, you need to call people, understand that. Most recently, we did a subsection E, and because of that, we were able to survive a summary judgment motion on the child abuse registry, which is a whole fourth dimension that I don't even want to get into the case, but we were able to get that dismissed along with everything else as a result of the subsection E. But talk to someone who understands if you have to make that decision. Best of all, if your client has some money, but they're hiring lawyers in the divorce, criminal case, and the DNN, under the DNN statute, even with higher income, they can qualify under quote extraordinary circumstances, which can include extensive litigation. So even though they don't qualify because they don't make too much, if the reason they don't have the money is because of all these excessive fees for all these cases that they're dealing with, all three of them, you can ask for a free attorney on the DNN under extraordinary circumstances. Custody fight, I'm not going to tell you anything about that because that's what family lawyers know about. But I do know one thing: if there's a TPO or a PPO, do that. In one case, we had the mother who made the allegations testify under oath that she was having audio and visual hallucinations about demons coming in and out of the children's bedroom. Very important later on in resolving the case with a dismissal. Also, I've had where we've gone in to litigate the TPO or PPO. How important is it? The DA walked in on the hearing and shut it down, gave us a win, basically dismissed the TPO, PPO. But that's how important it is, because they don't want us to have an opportunity to put anybody on the stand under oath. Where am I on time? What?
12:56.
Okay, I'm going to end it here. I have more. You can call me at any time for any reason. 303-440-4444. I'm going to end it with this, which is crush the weak. Now, when I say crush the weak, that sounds kind of mean, especially from a criminal defense attorney who's supposed to be representing the little guy all the time, right? And I'm personally a little guy myself. But it's more of an aspirational goal for me, in the sense that in nature, the strong prevails. It's just a matter of physics, right? The strong prevails. If you want to hope that the weak are somehow going to win, dream on. The strong prevails. So accept that. And in the beginning of a case, the prosecution with their investigators and the entire police department and the entire state of Colorado and endless resources are the strong. They start as a strong. So the only way to deal with that in a real world where physics applies and reality applies is for the defense to become the strong, right? And the defense can become the strong if you have the defendant, their entire family and extended family behind you, their friends, the defense attorney's staff, your experts, therapists. You get them on a diet that's a winning diet, so they're ready to fight every day. You get them exercising so they have the stamina to get through this process, and you buy them a new suit. If you have that, the defense becomes as strong. So I say, when dealing with these cases, all three, even the triple threat, crush the weak. See ya.